Wait for it. I know. Pay attention to me here. Don't look at me.
Let's get something is here and then something's in your expression, so it doesn't match. All right, good morning, everybody. Court will start with the January 26, 2022 docket. And let's see if we can bring in Mr. Gwynn. That'll be which cause number?
Number 4.
Number 4. Hey, good morning, Mike. How you doing?
Morning, Judge.
Yes, sir. Good morning. Are you here on CL 20-3469D in regards Jose Cervantes?
Yes, Judge.
All right. And what's the announcement, sir?
Yes, Judge. Defense counsel and I came to an agreement that we're gonna agree to the modification because the defendant actually got his driver license back, his actual driver license back, so he no longer needs an occupational license. And part of the occupational license was required for him to get a device. And now that he got his driver license back, he no longer needs occupational license, so he no longer needs the device for now. He will be placed on PTD, which will require him to get a mobile device, but that's later down the road, Judge.
Okay, so then an agreement is going to be submitted between you and Mr. Rubio Salinas?
Yes, Judge.
All right. All right, then that'll do it.
Thank you, Judge.
That'll do it. Thank you very much. Have a great day, sir. Bye.
All right.
Number 12. Mr. Garcia.
Yes, Your Honor. Good morning.
Yes, sir. Good morning, Mr. Garcia. You're here on P0151-21-4.
That is correct, Judge. We're asking for more time, Judge. There's a bench trial set for February the 7th on the divorce case.
Okay.
And we had agreed to wait till after the divorce to take care of everything else, Judge. So we would just ask for an extension of the ex parte order until after the divorce is final.
All right. Submit an order, Mr. Garcia.
Okay.
And for the record, we're here on P0151-21-4. Hermenegildo Martinez versus Claudia Martinez. Okay, sir?
Thank you, Judge.
It'll be more than 14 days.
It'll be more than 4. Yeah, it'll be
More than 14 days.
Yes,
be more than
that's fine,
14
Judge.
days.
No problem.
When was that other case set for? What day?
February the 7th?
February 7th.
Yeah, it's a F. Let me pull it up. I'm sorry, I had it right here.
Well, just put it in the order.
Somewhere.
Just put it in the order.
I will, Judge. Thank you.
All right. Thank you,
Thank
Mr.
you very
Garcia. Have a great day. You're excused. Thank you.
Thank you.
Yes, bye-bye. Who's your one kid?
That is what it is.
And-
789.
Okay, 789.
This might be his client.
Okay.
Good morning, Your Honor.
Yes, sir. Good morning, Mr. Ramirez. And I'm sorry, Miss Heather Hoff. Good morning, ma'am.
Good morning. My attorney should be here.
Who's the attorney?
Carlos
I'm sorry.
Flores.
Who's the attorney?
Carlos Flores?
Carlos Flores. Okay.
Yes.
All right.
Does Mr. Dennis have anybody in the waiting room?
Mr. Ramirez, anybody in the waiting room?
No, my clients are on standby, Judge. I believe that there's some procedural motions the court needs to maybe listen to first, and then also there's a new development, but I'll let counsel for the plaintiff speak first, and then I'll make my announcement, Judge.
Oh, okay, very well. We're here on cause number CL 21-3068D HHG Realty LLC et al. Versus Matthew Garza, Heather Cavapol Garza, and all occupants. Yes, sir. Good morning, Mr. Flores. You need to unmute, sir.
Good morning, Your Honor. How are you doing this morning?
Yes, sir. Good to see you, Mr. Flores. And then Mr. Ramirez.
Good morning.
Yes, sir. Gentlemen, what do we have here?
Your Honor, I filed 3 different things that are set for today. One is a motion for summary judgment that will resolve the entire case
Okay.
today. Another is a plea to the jurisdiction, which is not relevant for what what I'm gonna ask the court to do today.
Okay.
And then another is a request for writ of possession, which is tied to the motion for summary judgment. Just as a way of brief background, Your Honor, my client, HHG, is a landlord that entered into a lease agreement with the defendants. The term of the lease ended, and the tenants decided to remain. And they've been in the property despite the fact that they were given a notice to vacate by the landlord and given time to vacate. They refused to vacate, so then my client filed a forcible entry and detainer in JP court. The court granted possession to my client. And then at that point, the defendants filed this appeal. Since then, we filed a summary judgment, I would say like in October of last year, and we set it for hearing in December of this year. The notice was sent out by the court to all parties, and there is no response on file on behalf of the defendants. And so what we're asking the court to do today is to address only the issue of possession. This court has jurisdiction to adjudicate issues of possession and not title. Now, what Mr. Ramirez is about to tell you is that they have filed a lawsuit in district court, which my client has not been served. I haven't seen a copy of the lawsuit. You know, I'm not familiar with it. I received an email this morning about it, and he's going to argue to the court right now that the court does not have jurisdiction to determine the issue of possession. However, the case law is very clear that county courts at law have concurrent jurisdiction with district courts when it comes to issues of possession. The district court has the jurisdiction to hear title. This court has jurisdiction to determine possession. Since there's nothing on file with this court contesting title, and because the plaintiff is relying on the lease agreement, which is attached to our motion for summary judgment, then this court has jurisdiction to determine the issue of possession. Now, one last point, Your Honor. In the JP case, the court had ordered that the rent be paid into the registry of the court, and then this appeal came. Mr. Ramirez has reached out to me several times stating that he had the money to pay the rent, and I advised him to go ahead and file it with the court's registry. That hasn't been done. I'm not sure why. Perhaps he needed an order from this court or didn't need an order from this court. I'm not sure, but it's never happened. And so what we have here, Your Honor, is that my client has basically been without her property and without rent, having to pay attorney's fees since July. And what Mr. Ramirez is going to attempt to do right now, Your Honor, is he's going to attempt to try to delay more time by saying, Your Honor, I don't need to file a response to the motion for summary judgment. Please ignore that because I filed this case in this other court, even though in this case, I haven't filed anything to dispute title. And even though I have not done anything to try to serve that other case or get some kind of ruling in that other case that would impact this court right now. So based on that, Your Honor, I would ask this court to grant our motion for summary judgment. We filed an order yesterday evening. We're asking the court to grant immediate possession, to allow the issuance of the writ, to award my client approximately $20,000 in unpaid rent because there's a holdover provision in our lease that says that if you are a holdover tenant, you have to pay 3 times the monthly rent. So that's a rate of $120 a day. So the total amount of rent owed through today is approximately $20,000. I have the exact figure in a minute if I need to. It's in the order, Your Honor, in the judgment that we filed. In addition to that, Your Honor, we're going to ask for our attorney's fees for having to adjudicate this matter of possession. And that's about $1,400 and something. It's also in the order. And we're asking the court to apply a 5% post-judgment interest rate and to basically adjudicate this matter and conclude this case, Your Honor.
All right, thank you, sir. Mr. Ramirez?
Thank you, Judge. I think the first thing that the court needs to consider is the fact that since day one, when we appeared on this case, one of the first filings that counsel filed with this court was in fact a plea to the jurisdiction judge. advising the court that there was a title dispute. And because it's a title dispute, this court had no jurisdiction. Despite that, he has continued to try to avail himself of this court and to get rulings that run contrast to the fact that since day one, one of his first filings said, Judge, you don't have jurisdiction to hear this case. This is a case about title. Now, he's absolutely correct with respect to the fact that I have filed nothing in this court to contest title. I have not, Judge, because even if I had, this court has no jurisdiction to determine title, which counsel correctly recited to the court. The only court that can address title to real property is the district court, Judge. I can represent to the court that lawsuit against the defendants, Heather Hoff and HHD Realty, which are the plaintiffs in this case, has been filed. It's pending in the 389th District Court. Service has not been effectuated yet, Judge. I did reach out to counsel this morning to see if he would accept service or if I needed to go forward with service. That was barely today. I wouldn't have expected an answer before the hearing. And based on his argument, I will go forward with service. But the minute that lawsuit was filed, Judge, this court does not have jurisdiction to rule on possession, because in that lawsuit, I have filed a declaratory action that my clients are the owner and have title to the property. And I've also filed a trespass to try title with respect to the manner in which title was acquired and who title should be recorded in, Judge. So until that issue is determined, the issue of superior title, till that's determined, possession cannot be ordered by this honorable court. Counsel would now urge you, despite his plea to the jurisdiction and advising this court that you didn't have jurisdiction, now counsel wants to say, hey, in October, I filed an MSJ. Counsel didn't respond to it. Judge granted. So it's a very contradictory point when you say you don't have jurisdiction to hear it, grant my summary judgment because they didn't respond, Judge. So I believe it would be reversible error if this honorable court were to grant the summary judgment awarding possession, immediate possession, and or a writ of possession. With respect to the argument, just for the court's knowledge and information, with respect to the argument that the JP court ordered rental payments to be made into the registry of the court, that is not entirely accurate. And counsel had filed with the court an advisory letter in December to address that point and try to smear my clients. What I can tell the court is that in the original JP court, when the appeal was perfected and it was transferred to this honorable court, in that order and in the original order, there was never an order for the clerk to be able to accept rental payments into the registry of the court. While this case was pending, the plaintiff, Ms. Heather Hoff, without her counsel, filed another JP court action to try to evict my clients, now on different grounds. We had that hearing as well in the fall, Judge. She made similar arguments, similar smear campaign against my clients and myself. The judge did say, and I advised the court, Judge, I have rental payments. I have them in my possession. I can put them into the registry of the clerk, but we need an order. Or I can give them directly to Ms. Hoff or her counsel, which I had already asked since August or September. What do I do with these monthly payments that I'm receiving from my clients that I have in my trust account? To date, there's been no direction except from counsel. He finally did let me know. I believe it was in late October, November. He let me know it was the day after that second JP court trial. He let me know, put them into the registry of the court. I immediately advised them the next day. I went to the clerk's office to deposit the monies into the registry of the court. The clerk is not able to accept them because there's no order. How do I proceed? Do you want the monies directly to you, or do we do an agreed order to put those in? And we also both discussed, I believe there was dialogue to the fact that should we even put them into the registry of the court because of the state court action that would be to determine title. Nonetheless, Judge, I don't want this court to think that my clients are trying to work the system. I've tried since day one to work with the plaintiffs and their counsel to try to get them these monthly payments that were due to them pursuant to the contract and representations made to them. But what I'd like to impress upon the court is since day one, the first argument they made, pleaded to jurisdiction. Judge, you have no jurisdiction to hear this. Now, when they feel that they can use the court to their advantage to bully my clients, he wants to come to the court and say, Judge, grant the MSJ, kick them out today. You do have jurisdiction. very contradictory position. And my argument is that with the new case that's pending in the 389th, Judge, and I have that cause number for the court's availability if the court would so like, this court does not have jurisdiction to issue any ruling on possession at this time.
Your Honor,
Mr. Ramirez, Mr. Ramirez, how much money do you have? Or is it how many months or what? Or
I have the months of, I believe I have August, September, October, November, September, October, November,
I
December.
didn't get that. Could you try again?
Sorry about that. I believe it's monthly rentals in the amount of monthly payments in the amount of $1,200. And I have a total of 5 months, Judge.
times
Whether it's
5 months.
August or September, I don't have it. I don't have that accounting in front of me, but I do have the monthly payments from my clients in my trust account.
Okay, yes, sir, Mr. Flores?
Your Honor, is it possible for me to share my screen for a second? I'd like to show a couple of points to clarify some points that Mr. Ramirez just made.
And the only thing I'd object, Judge, unless it has to do with the plea to the jurisdiction,
Yeah, it has to do. with
I don't
plea
see
to
the relevance.
Yeah, it has to do with the plea to jurisdiction. If I may, Your Honor.
Okay, let me see if I can.
Okay, yeah, it gives me permission now.
Okay,
Okay, Your Honor, just to address the issue of the plea to the jurisdiction, here's the actual plea that I filed.
okay,
And if you see, it says there, to the extent that tenants contest title to the property. In other
okay,
words, it's subject to that, right? In other words, if they file defensive pleadings in the case or file something in the case that shows that they believe that there's a title dispute in this case, then I'm saying, hey, this court doesn't have jurisdiction to address that. But it's not a wholesale, the court does not have jurisdiction, only to the extent that they raise it in this case. Now, Mr. Ramirez can't raise it in another case and say that that's evidence before the court now. Okay, that's just not admissible evidence for the summary judgment. Okay, he could have filed a response where he could have attached that as evidence, perhaps. He could have filed a response to summary judgment where he could have attached his evidence of title, but he didn't. And multiple times prior to today, I asked him, please explain to me your theory of like why you say you have title or why you say that. And he never responded, never provided any information prior to that. So he can't save himself now. It is incorrect to say that I said this court did not have jurisdiction. As the court can plainly see what I filed, it says to the extent that they're going to raise a title issue in this court, then there is a plea issue, but that's not what's been raised here. And if I can, Your Honor, I'd like to share one more thing with the court.
okay.
Give me 1 second here.
And Judge, before he moves that item off, the actual plea language there does not say to the extent he raises a title dispute in this case.
Well,
It needs
it's obvious.
open-ended.
I mean, that doesn't have to be said, Your Honor. That's
And
all.
then in addition, the next sentence reads, the only court that has jurisdiction to hear the trespass tried title issue is a state district court. And that's exactly what's pending here, Judge. So that plea to the jurisdiction is currently in effect.
Okay.
Your Honor, give me 1 second. I'm trying to get this case to you real quickly, Your Honor.
Okay.
Let me just read you what it says, and I can give you the site. Give me 1 second here, real fast. Give me 1 second. I have it here. Your Honor, and I missed the case here, but let me pull it up here real fast. I'm sorry. I apologize for this. In the case called Salazar v. HPA Tex, Your Honor, and I can give you the site. It's going to be a Lexus site. It's a 2020 Tex app, Lexus 10279. It talks about how these courts, these county courts of law that are hearing appeals from forcible entry and detainers have concurrent jurisdiction with district courts. And I would like to read real briefly from this court here. Give me 1 second. I had it queued up and then it fell off. Here it goes. Okay, it says here, this is directly from the case, Your Honor. The existence of a title dispute, however, does not automatically deprive a county court of jurisdiction in a forcible entry and detainer action. It says here, only when an issue of title is so intertwined with the issue of possession that a court must resolve the title dispute before determining which party has a superior right to immediate possession does the court lose jurisdiction. And in this particular case, Your Honor, there was a lease agreement that was signed that also had an option to buy. And the tenants had actually met their option, had used their option to buy, but then failed to pay rent. And so the court held that the appellate court, which is the Houston Court of Appeals, held that the county court had a jurisdiction to hear it, despite that fact, because in that case, they had not raised the issue of title to determine the issue of possession the same way that we have here. Here, we do not have any allegations in anything that's been filed by Mr. Ramirez's clients, whether that be in an answer or a counterclaim or cross-claim or response to summary judgment or any kind of pleading that says, hey, Your Honor, here's evidence that there's a title dispute. So that all that is pending before the court today is, one, we have a landlord, which is HHG. We have tenants, which are Mr. Ramirez's clients. Two, we have the notice to vacate because the term ended. They refused to vacate. We have a judgment from the JP court saying that my client is entitled to possession. And so the issue of title is not an issue that is before the court today. Neither is it in the pleadings that have been filed, nor is it in any competent summary judgment evidence that the court can consider. So we would ask the court to grant the summary judgment today, which includes ordering the clerk to issue the writ. This does not stop Mr. Ramirez from pursuing his claim in the district court. This doesn't impact that at all. All it is doing is saying, we have a landlord here who has a superior right to possession. And that's what the court says. The law says, if you're the landlord and the term is ended, then the landlord is going to have the superior right to possession. That's not a title issue, that's a possession issue. And that's what we're asking the court to grant today.
All right, Mr. Ramirez.
And Judge, I just want to reiterate, since day one, counsel said this is a plea to the jurisdiction. You don't have jurisdiction to hear this to the extent that we raise a title dispute. You know, that title dispute has been raised. Title is so intertwined with possession because this involves a piece of property that my clients had contracted with the original owner to purchase. There was an assumption warranty deed, and that is how the current plaintiff received that property. And then she showed up to kick my clients out. There was an offer made to sell the property. My clients acted on that promise and that reliance. And that's what's pending, Judge. So to say you can grant the summary judgment, kick them out, and then let them sort it out in district court, that is completely contrary to the case law. That is completely contrary to common sense. And most importantly, again, Judge, he came to you day one and said, you don't have jurisdiction to hear this when there's a title dispute. There's a title dispute. It's in the 389th State District Court, Judge. That needs to be determined first before the issue of possession is decided.
And why was the plea to the jurisdiction filed in the first place?
Your Honor, it's something that we file whenever we have these cases, just in case there is a title issue that is raised in the JP or county court case. I did not have evidence that he was seeking title. It was just something that we filed as a precaution. And so that's what it was. Now, he had ample opportunity, Your Honor. I mean, we filed that, let's say, I'm going to say that's back now, like in August or September, Your Honor. You know, he had almost, 5-6 months now where, he could have filed an amended pleading, filed an explanation of what his title issue was, even just filed a response to the summary judgment. He hasn't done anything, Your Honor. And so now my client is going to be deprived of her due process rights to have the summary judgment ruled on because Mr. Ramirez didn't do his job. And that's just not fair to my client.
Mr. Ramirez?
Your Honor, obviously I take issue with counsel advising the court whether or not I've done my job or what has or hasn't been done, Judge. Again, day one, he said, if there's a title dispute, this court has no jurisdiction. I told him from day one, I am in agreement with your plea to the jurisdiction. Title's an issue. Title was an issue when we went to the JP court, Judge. The JP court order that says they're entitled to possession, that's null and void. The minute appeal was perfected, it's a trial de novo. So for him to say we have an order that JP court said she has possession is an inaccurate argument, Judge, and misrepresentation to this honorable court. So I would just ask the court to grant the plea to the jurisdiction and or abate this cause of action until the state district court issues a ruling as to title and possession.
But even if it gets abated, then it's got to be an order where you got to continue making those payments to the registry.
And so if the court wants me, I'll agree to it. I had asked counsel to agree to it. I can deposit those monthly payments into the registry of the court in this case while the state district court action is pending, or I can deposit it in the other case, Judge. That's not an issue. There's bigger issues here.
Well, what I plan to do here is go ahead and take the matter under advisement, and then hopefully next week I'll come up with a ruling. And depending on what it is, we'll see about that extra order or something for the deposit of the money in the registry of the court. Okay. So let me take it under advisement, and I'll read specifically again the plea to the jurisdiction and everything else filed in here, and we'll go from there.
Okay,
Thank you,
Judge.
Judge.
Thank you so much for your
All
time.
right. Thank you all so much. You all may be excused. Have a great day.
Thank you.
Likewise, Your Honor.
Bye bye.
Number 3, Mr. Sunny Palacios.
That'll be 7, 8,
And then
and 9. 7, 8, and 9. Mr. Palacios, good morning, sir.
Good morning, Judge. Mine should be a little bit easier than this.
Okay, cause number CL, there's never anything easy, but here, let's try it. CL 20-1779D, it'll be GIY International Corporation versus Diego Alarcon. It's a default hearing, right, sir?
That's correct, Judge. It's Sonny Balancas representing the petitioners. Judge, in this case, petition was filed in April of last year of 2020. Citation was issued by posting on several matters. Several times there's a motion for default judgment, affidavit of military status, certificate of last known address on 10/19. We'd ask the court to take judicial notice of all documents on file. There's in this case, a basic summary. My client purchased a Peterbilt tractor from defendants with be paid in payments. There was some warranties on the manufacturer and the vehicle or the tractor trailer. He took it in for repairs. They ended up selling the very vehicle that they sold him and required him to make all the payments. They contacted him to recover the vehicle. They went with Donna Police to recover the vehicle, the tractor trailer, and it was no longer at the lot. They've made several attempts to recover the tractor trailer unsuccessfully, and they're asking, they filed suit to recover. Defendants have defaulted, and we're asking the court to award $150,000 plus $3,500 in attorney's fees and court costs.
All right, then court will take judicial notice of the entire file in cause number CL 20-1779D in the case of GIY International Corporation versus Diego Alarcon. Court will hereby grant the plaintiffs all relief requested here in open court or in its petition. Court will await a default judgment order for signature.
Thank you,
Has
Judge.
one been submitted already, Mr. Palacios?
If not, Judge, we'll make sure we get one submitted.
All right,
We
go ahead and
should have
submit one.
submitted, but if not, we'll submit one.
All right, then that'll do it. Thank you very much. You may be excused. Have a great day, sir.
Have a great day.
Mr. Patrick
Okay,
Kennedy, number
bye-bye.
4.
Number 4.
ADA already made the announcement.
Okay, Mr. Kennedy.
Morning, Judge.
Yes, sir. Good morning. Are you here on the CL 20-3469D in regards to Jose Cervantes?
Yes, I am.
Okay, you already have an agreement with the state, right, sir?
Yes, Judge, Mr. Nguyen signed an agreed order and it's been submitted to the court for your signature.
Okay, that's the announcement the state made earlier today. So that'll do it then.
Okay, thank you, Judge. Have a good
Yeah.
a good day.
Thank you so much. You're
Thank you.
excused. Thank you. Bye-bye.
His findings, please.
And Mr. Cervantes is excused as well.
Thank you.
All right, have a good day. Thank you.
Mr. Jackson, we need to know what case he's on,
All right, let's put him on.
please. Correct.
Suited? Oh, no, that's gonna be Brenda. Yes, ma'am. Good morning.
Good morning.
Good morning, Ms. Hubbs. Which is your case?
Let me see here. That's going to be CL-19-0636-D.
Okay, that'll be Geico Company versus Margarita Reina and Cynthia Lambert.
That's correct, yes.
Okay, let me see who.
The defendant is
All right, let me see. I think defendant is on.
Mr. Jackson. What case is he on?
Yeah. Well, first of all, let me see. Let me ask Mr. Jackson. Can you hear me, Mr. Jackson? You need to unmute, Mr. Jackson.
Yes, I can hear you, Judge.
Which is your case, Mr. Jackson?
I'm here with Mr. Correa, number 10 on today's docket. It's a civil case.
Okay.
Okay.
Okay, we'll call him later.
Just a moment.
Okay, hold on, Mr. Jackson. We're going to call you in a while. Okay, sir?
Yes, sir.
All right, thank you. Let me see here. Margarita Reina, I think she's on.
She's on mute.
All right, can you hear me, ma'am? You need to unmute.
Yes,
Right down there. You can talk.
this is
All
me.
right. All right. Good morning, ma'am. You're here on CL 1906-36D Geico Company versus Margarita Reina and Cynthia Lambert.
Yes, Margarita
All right.
Reina.
Okay. Did you ever get an attorney, ma'am?
No,
You don't have an attorney? Okay.
no, I don't.
Okay. And Ms. Hubbs, this case is what? MSJ, motion for summary judgment?
That's correct, Your Honor.
And this is in reference to what? An accident?
It is, Your Honor. I represent Geico in this case.
Okay. Was there a response filed by anybody on this one?
Not as far as I'm aware, Your Honor.
Okay. No response. All right. Well, I'm going to go ahead and take judicial notice of the entire file in CL 1906-36D, Geico County Mutual Insurance Company versus Margarita Miyabe Reina and Cynthia Lambert. Is this MSJ as to both defendants or just one of them?
As to both, Your Honor.
It'll be both,
Mhm.
and neither has filed a response, right, ma'am?
That's correct.
Okay. You may proceed, ma'am.
Yes, Your Honor. A motion for summary judgment is based on the admissions that this court ought to deem admitted based on the fact that they were not responded to. And we've also included our affidavit showing the damages and the police report showing the liability. And as a result, this motion for summary judgment should be granted by this court.
Okay, so actually what you're looking forward here, you're looking forward to a judgment here that we can be sent later to the defendants, and then after that, they can still try to work it out with the Geico if they can or not, right? Is that the understanding?
That's the understanding, Your Honor.
Okay, but for the record, there's no responses from either side to the MSJ, right, ma'am?
That is correct as far as I'm aware, Your Honor. If the defendant knows that she filed a response, I know that we didn't get one, so
Okay.
but that's as far as I'm aware, yes.
Okay, Ms. Reina, do
Yes,
you understand what we're doing here?
no, no, I
Okay,
don't.
okay, it's a motion for summary judgment whereby the plaintiffs are trying to get a judgment against you and Lambert to pay up some damages that you owe, and since there's no response and basically no defense to it, it's going to get granted. And what is going to end up happening is going to be a judgment against you that you're going to be getting in the mail or email, and then with that judgment, you can then continue talking to the people to see if you can work something out.
Okay.
But tell them.
Well, the thing is they're accusing me of hitting them. As you can see here, I have my pictures. That's my bumper right there. I didn't hit anybody. I was struck by another person, the one that was driving the Envoy. She was the one that hit me crossing the intersection there. And then the person, which is Geico's client, he hit me, as you can see on my rear bumper. I didn't hit anybody. I didn't hit anybody. As you can see, this is my front bumper. And this is where the client from Geico hit me. And this is where the person first struck me. As you can see, I didn't hit anybody.
Uh-huh. So you were
So,
hit?
I was hit first, yes, by the lady driving the Envoy. She hit me first on my what is it, the driver's side, which is me. As you can see there, she hit me right there. She spun my truck. My truck was spinning, and then the client from Geico hit me from behind onto the other side, right there.
Okay. Did you ever hire an attorney?
No, the reason is I'm disabled. Right now I'm going through a lot of issues. As you can see here, I just had another carotid surgery.
Okay.
So I don't have the time. I don't have, because I didn't hit, as you can see, my tires are broken there where the other car struck me, the Envoy, and she spun my truck. I didn't hit anybody.
Okay, ma'am. And did you have insurance?
I didn't have insurance at the time, no. I didn't have insurance, and I didn't have a license. I guess that's why they're coming at me. But that lady, my report was totally changed. I don't know if you have the police reports there in front of you.
No,
My
ma'am.
reports were totally changed. The officer de la Rosa that took the report said that Unit 2 was driven by a 66-year-old man. There was no 66-year-old man driving that truck. The Envoy was driven by a lady, a woman, which I can say was maybe in between her 45s. And then there was a passenger also that, because I saw them both jump out of the truck and come to me to see if I was okay.
Okay.
And so right here, the officer put that there was no other passenger and that it was a 66-year-old driver, which was not a 66-year-old driver. It was a woman, I'd say maybe in between her late 45s. The thing was, I was taken to the hospital.
Okay,
because
that's
I had
fine.
open heart surgery.
Okay, and Ms. Hubbs, in your motion for summary judgment, you said you submitted the police report?
That's correct, Your Honor.
Yes. The thing is, in my before I had worked for an insurance company, so I was kind of related. I sort of like knew about insurances, right? Accidents. So I told them. I went back and I told the supervisor. I told them right here, which this is your original, as you can see. This is your original right here, as you can see. He stated, the police officer stated that Unit 1 hit me, or actually that I hit Unit 1. So when I seen this, I went back to the police station and I told the officer that that it didn't happen that way. I didn't hit anybody. So he went back, and as you can see here, he said all we could do was amend it. And that's where you can see that he sort of like changed the drivers and where the accident was hit.
Okay, Ms. Hubbs, the report, the police report that you submitted, was that the amended one or the original one?
I seem to have the same report that Miss Reina has.
The amended one?
That's correct.
Okay, but you don't have the original one?
Oh, it looks like we actually submitted both because we've got both of them on here in the filing that we have. Yeah.
Okay, and I don't have any report in front of me right now, but I will look at it later.
I appreciate it because
and tell them that they were supposed to ask for the body cam.
They were supposed to, as far as I knew, what they had told me, they were gonna wait for the body cam. Because I went back and I spoke to the supervisor and I said, this is not right. I said, I was not struck by a 66-year-old man.
Okay.
I said, so, and he went and he told me that he was gonna go ahead and ask the officer for the body cam. So I said, okay, these were my exact words. And this is a person that hit me. And this is a person that jumped out from the passenger side of the Envoy.
Okay, and Ms. Hubbs.
It was a 3-vehicle accident, not just 2, it was 3.
And where did it happen? In the expressway or what?
On the expressway, yes.
Okay, somewhere in West, what?
On Goodwin, over here on Goodwin.
Okay.
And Expressway. Right
Mission Palmview area. Okay, ma'am, Ms. Hubbs. So how are you alleging the accident happened?
Judge, we're alleging that the accident happened the way that the police report says it happened, that Unit 1, in other words, Ms. Reyna, failed to yield the right of way at the open intersection and caused the accident by failing to yield the right of way. She claimed that she had a green light, but because, she did not, she entered the intersection and the other drivers crashed into her vehicle when she should not have been there.
No, because right here it says two.
Ma'am, it is my turn to speak.
Yeah,
Okay, I'm sorry.
let her speak. Yes, ma'am.
I'm sorry.
Yes, and moreover, that's not really relevant to our motion for summary judgment because our motion for summary judgment is based on the fact that Ms. Reyna failed to answer any of our requests for admissions, so they've been deemed admitted. And for that reason, this motion for summary judgment should be granted.
Oh, okay. So based on the fact she was she was served with admissions that
Correct,
she did
Your
not
Honor.
answer.
That's correct, Your Honor.
Okay, all right, then what court will take the judicial notice of the entire file and we'll go ahead and take the matter under advisement and we'll go ahead and hopefully have a ruling next week. But
Thank you.
that'll do it. Thank you all very much. You all may be excused.
Thank you. Appreciate it. Bye.
Thank you. Bye-bye.
Judge, could I ask you something? I'm sorry. What questions did I refuse to not answer or?
Well,
What
just
did they
claiming
do?
some discovery. When there's a lawsuit, there's some discovery that is sent to you. Questions that you must answer.
No, I have not received anything like that. Every single paper I received, that's why I have been trying to go to court every time I am, called in because.
I'll look into that and everything else. Okay, ma'am?
I appreciate it very much.
Yes, ma'am. All right, thank you. Bye-bye. What do we have, Mr. Jackson?
Mr. Jackson, number 10.
Mr. Jackson, welcome back, Mr. Jackson. Number 10. Yes, sir. You're here on CL 213741D, Soraya Carbon Cosiglio versus Jose Correa.
That is correct, Your Honor.
And you represent who now?
I represent the interest of Mr. Jose Correa and the property owners.
Okay.
Yes, Leonardo Nunez.
All right. I see Soraya Carbon. She's there right now. She's the plaintiff.
She's the defendant, Your Honor. This is an appeal from JP Court in which the judge awarded us the possession of the home since we are the homeowners and she just hasn't paid us rent in a year. And that's basically what it is.
Okay. Then we set it for bench trial. We're going to do a bench trial, Mr. Jackson.
That'll be fine, Judge.
Let me give you a date for that.
Okay.
So then I can hear both you and I guess your client and then Ms. Carbon. Is it Carbon? Is that the last name?
It is, Your Honor.
Carbon. Okay. All right.
May 2nd. But I need an order.
Yeah, we need an order. I need an order, Mr. Jackson.
Order setting hearing?
Submit an order setting hearing for bench trial or
bench trial. Okay.
Now, make sure that we got everybody's email, right? Everybody's information.
Yes.
So they can get copy of the order.
Yeah, I'll do the CCs, Your Honor, on the order.
All right. You have the information already from the other parties?
Yes.
Or should we put some addresses and phone
If
numbers?
we could put it on the record, so that way we don't have any excuses as to why they, for the hearing.
right.
Just ask Ms. Carbon if she would like to be sent through via email or personal service there at the home.
Okay, Ms. Carbon, you need to unmute.
Necesita poner el sonido.
Sí, perdón. Buenas tardes, señor juez.
Yes, ma'am.
¿Pudiera ser en español para yo poder?
Señora, yo le voy a traducir. Ahorita lo que el juez
¿Sí?
está pidiendo es, necesito un domicilio donde usted recibe correspondencia.
Es aquí en la 2605 Truman Avenue, Mission, Texas, 78574.
2605 Truman Avenue in Mission, Texas, 78574. La calle es Truman.
Truman.
¿Cómo se deletrea? Do you have an
Perdón.
address here? Mr. Jackson, do you have an address for her right
Yes,
now?
yes, I do. I have an address for her, Your Honor. It's on the contract. It's 2605 Truman Street, Mission, Texas, 78572.
Okay, that'll do it. That's the notice. That's what
Okay.
you're gonna get the notice.
We'll put it on the CC.
Este caso se va a hacer una audiencia y la corte le va a dar una fecha y va a mandarle la notificación a este domicilio. Es importante que cuando usted lo reciba, ya sea por Zoom, no sé si va a ser por Zoom o si va a ser en persona, es importante de que si es por Zoom, lo haga y si no, tiene que ir en persona a la corte.
Okay.
Es todo por hoy.
Okay.
Muchas
Thank you,
gracias.
Judge. Have a wonderful day. Stay safe.
Thank you. That'll do it.
Yes, sir.
Bye-bye. Thank you. What else we have right now? That's it?
I need to know what these ones. Let me see who these people are.
All right.
Okay, Denise is number 11, but we need to know who these people are.
Number 11.
Mariana Mejia and these two.
Okay, we have, this is Varona.
Mejia and this.
Okay, there's Mejia and
Jaime Hernandez is with her.
okay.
So he's gonna log on.
He's gonna log on. Okay.
Okay, right here.
All right. Can you hear me, Mr. Mejia?
It's on you.
You need to unmute.
Sí.
Señor Mejía, ¿cuál es su caso?
De las señoras, tenemos una casa que la señora Soraya Carbonell, no sale de la casa que le estamos rentando.
Un momentito.
Okay.
Ese caso, su abogado es Roberto Jackson.
Sí, claro.
Okay. Lo que va a hacer la corte va a hacer una audiencia. El señor Jackson va a archivar una orden, ahí vamos a poner la fecha, ya sea que va a ser por Zoom o en persona. Usted nada más está en contacto con su abogado.
Sí.
Gracias.
Gracias.
Okay, thank you. Have a great day, sir. Buen día.
Right here, I don't know who this is.
Okay, we have Gerardo Varona who is connecting. And I think Mr. Jaime Hernandez will be showing up.
Judge, and for the record, Mr. Hernandez texted me that he was at an in-person hearing in the 449th, but was going to make some time to log into our court.
Okay. It's a status here in JP Court, right?
I don't know if you want to ask her what it's about.
Okay, Miss Denise Aguilar, I think we're waiting for Mr. Hernandez.
Okay.
Do you have an attorney, ma'am?
No.
Okay. So I think Mr. Hernandez represents Stop Shine Car Wash.
Yes, I think so.
Okay. Yeah, we're waiting for him. He's supposed to log in.
Okay. Can I speak in Spanish?
If you understand English,
Yes, I a little bit, but to understand better, I can speak Spanish.
well, right now you're doing very good. So I wish you would continue. Let me see. Let me see first what we're gonna do here in this case.
Okay.
Set for status. All right, now Miss Aguilar,
The attorney is
Yes.
busy in another court.
I cannot get the attorney to join us. So
He's busy in another court.
he's busy in another court. So what we're gonna do is set this matter for another hearing date,
Okay.
and we're gonna send notices to everybody to appear again. What is your address, man?
What is my what?
Your address, domicilio.
Yes, 4012 North 43rd Street, McAllen, Texas.
43rd Street, McAllen, Texas.
4012 North 43rd Street, McAllen, Texas.
Yes,
78503 or 004?
04.
Okay, there we go. All right. And Mr. Varona, he's there. Yeah, you need to unmute, Mr. Varona.
What case is he on?
I think we call. Oh, can you hear me, Mr. Varona?
Yes.
Okay.
Sí,
good morning. Good morning,
morning.
sir. Which is your case? Your case number?
El caso, el nombre del caso tuyo. Es Diego Alarcón. Es una estafa que nos hizo el señor Diego Alarcón.
Oh yeah, number 3. Oh, that was a default hearing. A default hearing, Mr. Palacios. Let me see.
Sonia Palacio.
Señor Alarcón, ¿Sari Palacios es su abogado?
Sí, es correcto, es correcto.
Ok, ese caso ya se oyó temprano. Lo que pasa es que cuando usted se mete a Zoom y no pone su nombre, la corte no puede identificarlo, ¿ok? Pero su abogado este caso ya se llamó y la corte le concedió al abogado lo que estaba pidiendo. Usted comuníquese con su abogado.
Muchas gracias y disculpen la falta de conocimiento.
Ninguna,
Perdón.
ninguna. Que pase
Okay.
buen día, señor.
Ok, gracias.
Gracias.
No, gracias a ustedes.
Yes,
Hasta
sir.
luego.
Yes, sir.
Bye-bye. Okay, we got her address, right?
Yes.
4012 North 43rd Street, McAllen, 7504. Okay, we cannot get Mr. Hernandez in here to, what we're gonna do is, we're gonna reset it for it'll be trial and merits. Bench trial. And we will send notice to everybody involved here. We already have Ms. Aguilar's address, but you'll get another notice.
Señor Aguilar, lo que va a pasar es que como su abogado, el abogado Hernández está ocupado en otra corte, hoy no se va a hacer nada. Lo que va a pasar es que le vamos a pedir al señor Hernández que archive otro documento, una orden, y así ahí la corte le va a poner la audiencia, la siguiente audiencia que va a ser un trial, a bench trial, ¿ok? Es importante que ahí va a indicar si va a ser por Zoom o si va a ser en persona. Y en ese día la corte va a oír su caso, o si usted tiene evidencia, tiene fotos, tiene testigos, tiene lo que usted va a presentar a la corte, tiene que presentarse con todo eso o las personas ese día. ¿Ok?
Ok, señoría, lo que pasa es que yo soy la que ha metido la petición. No sé si lo tenga que hacer yo.
Your Honor, the only thing is that I'm the one that has submitted everything. I don't know if I have to do it. Un momentito, aquí viene el señor Hernández.
Okay.
He just logged on.
Okay.
Just ask Jaime to do it.
Yes, sir, Mr. Hernandez, he's connecting. Can you hear me, sir?
Good morning, Your Honor. Yes, I can hear you.
Yes, sir.
And first and foremost, I do want to apologize to the court. I am in a in-person hearing out of the 449.
Right.
So I apologize
You
for
are
my
correct. I
tardiness.
heard that earlier. Okay, welcome here. And I think you're here on CL 213843D, Denise Aguilar versus Top Shine Car Wash.
That is correct, Your Honor. Jaime
Right.
Hernandez on behalf of Top Shine Car Wash.
And today was status hearing.
Yes.
What we're going to order here is a bench trial and
Okay.
give all the parties involved here a notice so we can hear the evidence on this matter.
Okay, Judge, can we also, Your Honor, get a discovery phase as well, just a discovery deadline so that we can conduct discovery with the opposing side?
Yeah, well, just follow the rules.
Okay.
And then I won't give it a trial date yet. Why don't you do some discovery first, and then we'll go from there.
Absolutely.
Yeah, go from there. And what is this case about?
Your Honor, this case stems out of there was a contract for repairs. Well, the opposing side is claiming that there was repairs done on the vehicle that she did not approve. And my client is saying that Top Shine Car Wash, and I know it sounds funny because it's Top Shine Car Wash, but they also do
repairs
in the back. Yes. And so my client is claiming that those repairs were approved by her. She's claiming they were not approved by her. And so the issue stems from the payment of those repairs that were either approved or not approved. And of course, that will be for the court to decide.
And this is an appeal from JP Court?
That is correct, Your Honor.
Okay. Her address, I don't know if you have it or not, is 4012 4012 North 43rd Street, McAllen, 78504.
Got it, Judge.
All right, submit the order for the, don't submit anything yet. Do some discovery and then let us know when you're ready.
Yes, Your Honor. Thank you.
Okay.
Yes, and I will
All
be
right.
in contact with Ms. Aguilar Padrón.
Okay.
So, señoría, quería saber si se va a hacer este caso, se va a quedar pendiente para la siguiente.
Your Honor, I want to know if this is going to be pending for next time.
Yes, it's pending. What's going to happen here is that Mr. Hernandez is going to be sending you some discovery for you to answer. So await that in the mail, okay, ma'am?
Si ahorita por lo pronto va a estar pendiente, lo que va a pasar, el señor Hernández le va a mandar a usted un grupo de preguntas que usted tiene que contestar, que se llama Discovery, ¿ok? Para tratar de a ver qué es lo de este caso. Ya terminando el Discovery, entonces la corte lo pone para un bench trial.
Ok, me lo habían estado mandando por correo electrónico
They have been
porque,
sent it to me through email.
porque
Yeah.
la última vez lo entregaron a una dirección incorrecta,
Oh, then
el
she'll
cual
get email. Yeah.
¿Cuál es el email de usted?
es denise.aguilar90@icloud.com.
Got it, Judge.
Did you get it, Mr. Hernandez?
Yes.
Repeat it?
Yes,
Can
Your
you
Honor.
repeat it?
It's denise.aguilar90@icloud.com.
Yes, es correcto.
Okay, great. Very good. Okay.
It's Denise, the way it's spelled there, ¿verdad? Denise, Denisse.
Yes.
Okay, perfecto.
2 S's. Okay, very well. Then good luck with that, okay?
Thank you, Your Honor. May I be excused?
You all may be excused. Thank you very much.
Thank you.
Have a good day. Bye-bye.
Likewise. Bye-bye.
Need to end it.